A very good morning to everyone. Atal Mishra this side from Department of Law, Mewar University. So today we are taking up the unit 1, which is law of contract. So basically in this particular subject we would be taking up the important points on how the contracts are regulated in our country, what is the legal basis for it, and what is the legal framework which regulates the contract in our country. So basically, first overview of about the Indian Contract Act is it was enacted by the Britishers when they were ruling India, as we can clearly see from the commencement date. In it is which is September 1st, 1872, and it was enacted by the British Parliament, and it provides the detailed set of rules and guidelines that will ensure the legal certainty in commercial transactions solved. And there is it covers majorly all type of contract, including the business agreements, service contract, lease agreements, and personal agreements. And it also laid down the comprehensive framework for the legally binding agreement and how they would be enforced in the court of law. Moving further, the definition of the contract, the very most important definition, which is section 2H of the Indian Contract Act, which defines contract as an agreement enforceable by law. So this definition implies that not all agreements are contract, only those agreements are legally enforceable qualify as a contract. So we need to remember here all agreements cannot be contract, but all contracts may be the agreements. Okay, so moving further, agreement plus enforceability is subjected to the contract. For an agreement to be considered as a contract, it must fulfill two main conditions, which are: agreement is a mutual understanding between the parties, and it would be for any particular thing or substance, and it may be the certain set of promises as well. And enforceability means the contract must be fulfilling all the legal requirements. It must not be against the uh, rules and regulations of the which is already been set by the law, and it is binding in the court of law as well. Moving further, we have a nature and kinds of contract. It says first one is basis of the validity, which says that base contract can be classified accordingly to their legal enforceability and validity. The first is valid contract. What it says is a contract that contains all essential elements, making it's legally enforceable by law. It is binding on all parties. So basically we have this is the definition for the valid contract. Second, moving further, what we have void contract. It is specifically defined under 2J, section 2J of the Indian Contract Act. What it says: a contract that was valid when found but become unenforceable due to change in circumstances or legality. Here we can understand that the moment the contract was being framed, it was legally binding, but the moment there have been certain situation or circumstances arises which made this the legality of those contract questionable. So at that state, that contract would be considered as a void contract. Further, we have voidable contract, a contract that is initially valid but can be voided or cancelled at the option of one party, typically because of the factor concerned like undue influence, fraud, or misrepresentation. It is defined under 2I of the Indian Contract Act. We all know there might be situation that contract if someone is forcing someone to sign a contract, and that person is in the better position or in the higher position or have any influencer post, so they can basically influence a person, and coercively they can force any person to sign a contract. So on those things, if the other party successfully proves these points that yes, while I was making a contract, there was no free consent, I was under the undue influence, or I have been coercively forced to sign this particular contract, then on those grounds that contract would be considered as a voidable contract. Then we have illegal contract. What it says, the contract involving the activities which are not considered valid under the law, which cannot be acknowledged by the law. So such contract are not only void but are punishable as well. As we know, if any contract has been framed that is against the public will, or any law considers those things as illegal or punishable, so we can take those things as a ground or a consideration for a contract, that would be considered as a illegal contract. Then we have on the basis of formation. What formation says, first one is express contract, where a contract, the term are expressly stated either in writing or verbally. These there is a clear agreement between the parties regarding the terms and obligations. Implied contract, what it says, the contract formed by the conduct, action or circumstances of the party rather than a written or a spoken word. For example, ordering food at the restaurant implies a contract to pay for the meal. So here initially there is no like a specific contract between you and the owner of the restaurant, but it is an implied obligation that we are supposed to pay for the meal which we have ordered, which we have got from the restaurant. Then we have the concept of quasi contract. What it is specifically stipulated, included under the Indian Contract Act within the section 68 to 72. Initially, quasi word we can understand like it would be says yes, like of, near about. So these are not true contract but are imposed by the law to prevent unjust enrichment. They arise when one party benefit at the expense of another. So equity demands compensation. So these contracts are arising to substantiate the balance of convenience between the parties. The reason being, if one party is somehow got benefited of any conduct of the other party, so the party who is at the loss need to be compensated. So basically, for considering those things, this quasi contract concept was adopted. Next we have nature and kinds of contract we were discussing, and it would be based on performance. What performance is, executed contract, a contract in which both the party have fully performed their obligations, it is completed and no further action are required. Executory contract, a contract where some or all of the obligation remaining to be performed, the performance is scheduled for a future date. And unilateral contract, a contract in which only one party makes a promise in exchange of an act of the other party. The contract is formed when the other party performs a request, example, a reward of finding a lost item. Then we have a bilateral contract, a contract involving mutual promises between two parties. Each party is both a promiser and promisee, promises to perform certain obligations. So these are considered as bilateral contract. Then we have the concept of consideration. As we all know, like without consideration a party cannot a contract cannot be held legally valid. The context we can get from the consideration, that the very famous legal maxim which says quid pro quo, something in return of something. So basically the consideration have gained its basis from this particular concept only, that determines that it is an exchange between the parties. So consideration can be an act forbidden or promise to do or not to do something. So it is consideration maybe in the positive medium or maybe in the negative medium as well. Moving further, what specifically Indian Contract Act says about the consideration is more important to discuss about. According to the section 2D of the Indian Contract Act, it says the consideration is the price paid for the promise of another. It also involves something of value which is each party must give or promise to give to make agreement enforceable. So in legal terms, we can understand that when at the desire of promiser, the promisee or any other person has done or abstained from doing something, we need to notice the most important thing here is in an contract or an agreement consideration. It is not mandate that must be the positive thing, negative as well. As here we can see the word abstain, like you can, it can be in the negative term as abstaining someone from doing something. So it is considered as a consideration for a valid contract. Moving further, we have essentials. What are the essentials for the consideration? It must be real, it must be lawful, not vague. We need to understand these concepts because it plays a pivotal role for any contract to made it enforceable and look like a legally binding before the court of law. The consideration must be real. It must be something that can be tangible, identifiable, or real value. It should not be something illusory or factious, and must be lawful. Most important thing. Otherwise, it would be considered as a voidable contract. Consideration should not involve any illegal activity. Okay, otherwise it would be considered as illegal contract as well. And as we have already studies in the contention for the illegal contract, we have not only the we have the concept of punishment as well. And it must not be immorality or against action against the public policy. The consideration, while parties are contracting in between, they have to keep these things into consideration while considering about the consideration, what thing they are going to consider for it. And moving further, the consideration must not be vague. Moving further, rule no consideration, no contract. As we have already studied the maxim quid pro quo, which specifically says something for something. If there is no something, like if party is not getting something in return, how it can be considered as a contract? So it rule says no consideration, no contract. There cannot be any contract without an consideration. A general rule, a contract without a consideration is void. So you cannot, it would be considered as if there is no consideration at all in the contract. But yes, we do have some exceptions to it, which is already stated under section 25 of the Indian Contract Act, which says if we are giving something out of natural love and affection, that is considered as an exception under the Indian Contract Act. Second one is compensation for post voluntarily service. If you are compensating for something, then it would be considered that you have already have paid the you are under the obligation or you are under the debt of consideration, so you are compensating it. And voluntarily services. And last one is promise to pay a time bar debt. So these are some exceptions which are being categorically stated under India Contract Act under the section 25. Moving further, capacity of the parties. The first thing we were discussing, that minor cannot be the cannot be the party to the contract. Other contract with the minor would be considered as void ab initio, which basically means, the meaning of void ab initio says from very beginning. If you are contracting with a minor, it is considered as a contract void ab initio, and it is not enforceable by law. Reason being, we have already discussed section 11, which categorically the starting says every person must be competent to contract who is age of majority. So it has been specifically barred the minors to enter into a contract. The very famous case of India, which was decided by the Privy Council, Mori Bibi versus Dharmodas Ghosh, it's 1903 landmark judgment, where it was categorically stated that the contract with the minors at void ab initio. Next, we have person of sound mind. That is very important, because if person is not a sound, not in the good condition, how he will understand the condition of the contract, how he will agree to the whatever points you are saying. So what are the terms and conditions of the contract? So these are the some important guidelines which it must be taken into consideration while deciding or considering the capacity of the party from whom we are going to make a contract. Then we have disqualified person by law. If any person who has been disqualified by the law, how we will understand this disqualification? We have three bifurcation under it. The first one is insolvent person, who don't have the person who has been declared as insolvent by the court is not, and their assets are managed by an official receiver or assignee, and in these cases that particular person is disqualified to make a contract. Then we have alien enemies, that is the foreign national of the country in which with which we are in war with. So the agreement with these the nationals of those countries may be threat to the national security, so those people are barred from making a contract. Then we have convicts. We don't have any specific consideration under the convicts, but yes, we have some bar on convicts in making a contract, because they are already restricted by the under the law. Then we have the important thing which we need to understand, that is free consent. Whether the party the party must be free from any influence. Influence means it should not be forced to perform or sign an agreement or to make a contract. Without a free consent, how we will ensure that yes, the party have agreed upon same terms and condition or not. So section 13 accordingly says that free consent when it is free, it would be considered as free when it is not influenced by coercion, undue influence. Undue influence, very important, because if any superior authority who is the authoritative position, he may force the juniors to perform any act or duty. So on the garb of that duty, he cannot force any person to make a contract. Then we have misrepresentation. That is also a major concern for the consent of the parties and or mistakes. Next we have coercion, which is specifically discussed under section 15 of the Indian Contract Act. Coercion involves forcing someone to enter a contract through threat or use of unlawful means. So we need to understand the person threatening another person. If you are threatening someone to I will harm, otherwise harm to their life or property to sign a contract, that would be considered as a voidable contract under the Indian Contract Act, because there was no absence of free consent of the parties. Next we have undue influence. As we all know, any person who is at the authoritative position, he may force his junior to perform certain duties or works. On those situations, there is a situation. On those situations, there is a condition. There may be the possibility that he may force to do something as junior would take as an obligation or as an order to perform some duty, but under those situation he cannot be forced to sign on a contract, otherwise it would be considered as there was an absence of free consent. Then we have fraud. Again, this is very important contention with respect to the free consent. Fraud refers to the intentionally deceiving another person, another party, to induce themselves into the contract. The very example we can understand with selling a car by falsely stating that it has been never been an accident. So basically we are deceiving the party. We are not we are intentionally keeping them in the dark and not telling them the whole reality. Then we have misrepresentation, the most important in the seller knowingly claiming the product has been certain feature that it does not have. Initially, misrepresentation means involve an innocent yet false representation of fact that induce a party into a contract. That knowingly, you are knowingly asking someone to sign the contract, and the consideration which you are making, or the representation you are making, that is false, that is vague, and on those situations, if the other party successfully proves that there was a misrepresentation from the contracting party, the contract might be considered as voidable, and it would be considered that there was not the free consent. Then we have mistake, section 22, which say that mistake, it can be the mistake of fact, mistake of law. So mistake of fact occurs when both parties are under a wrong belief regarding the fact that is initial to the contract based on mutual mistake for the fact are void. Then we have mistake of law. A contract is not void if it is based on the mistake of Indian law, but mistake about the foreign law, it is treated of the mistake of fact. Then we have legality, object and consideration. Section 23 states that the object and consideration of an agreement must be lawful for the contract to be valid if the subject matter or consideration is illegal or contrary to the law, the contract is void. The reason being the contract involving the illegal activities such as smuggling or drug trafficking or counterfeit production. These things are considered as like illegal activity, and consideration, of course, it would be unlawful. So this contract will not be enforceable by law, and it would be declared as a void contract. Then we have when object or consideration is lawful. We have if it is forbidden by law, if it is defect the purpose of law. Then we have involved fraud on legality and object under it, which says that causes injury to a person or property. Second is considered immoral or opposed to the public policy. While performing or signing a contract, we have confronted this particular word, public policy, again and again. So basically this public policy term means that we cannot make any contract which is against the public policy. Like what it categorically says that contract that involve act deems immoral by the society standard, that doesn't comply with the standard of the society, and which goes against the broader public interest, that are the void contracts. This we need to take into consideration. Again, causes injury to person or property. If agreement leads to the harm to the person of individual person, property or legal right, is void. For example, a contract to damage a rival property or physically harm a person, these contract would be considered as void contract. Then we have void agreement. Void agreement is an agreement that is not enforceable by law. Again, 2G says that Indian contract states that agreement not enforceable by law are said to be void. It is categorically stated in our Indian Contract Act. Moving further, sorry. Then we have agreement without consideration, section 25. Those are also considered as a void contract. have already studied. Again, most important, void agreement to restrain of marriage. Again, section 26 say you can restrain someone from marrying otherwise if you are making such consideration or such agreement, that would be considered as void. Again, agreement to restrain of trade, you can't also restrain someone from performing the trade activities, otherwise it would be considered as void contract. Again, there are exception, reasonable restrictions as not compete clause in the employment contract. Sales of goodwill are enforceable. Then we have agreement in restraint of legal proceeding. Again, we all know, like, you cannot stop someone from approaching the court of law. So in case it has been categorically stated here that you cannot restrain someone from legal proceedings. Again, we have uncertain agreements. Section 29, agreement with uncertain ambiguous term that cannot be clarified, understood, or void. So these things are also considered as void agreement. Then we have legality of object and consideration. What it says, wagering agreement, section 30, agreement based on chance or uncertain event where one party stands to win or lose based on purely the outcome are void. Reason being, gambling or betting agreement, horse races, these things are considered as the wagering agreement, because there is an uncertainty. There is a situation there one party will win and second party will lose, and the outcome is unforeseeable. Then we have a differentiate void contract. What are void contract and voidable contract? That is very important to understand. The void contract is not enforceable from very beginning, as we all have already studied. A contract with a minor, it considered as a void ab initio. Then we have a voidable contract, a valid until annulled. It is seen that it is an agreement that one or both the party have opted to option to each other continue or risking depending upon the certain factor such as coercion, undue influence, or fraud. Then I have also make a chart to differentiate between the void and voidable contract. What it says, the first one is enforceability, non-enforceable by law from the outset, and for the voidable contract, enforceable unless annulled by the affected party. Then causes of voidability arise due to illegal object, lack of consent, of other legal deficit, as we have already studied in our previous slides. Then under the voidable contract arise due to coercion, undue influence, fraud, or misrepresentation. Parties right, no legal right or obligation arise from either party. Party have the right to either enforce or annul the contract. Moving further, remedies. What are the remedies in case of breach of contract? The section 73 to 75 categorically state about the remedies. Moving to the 73, what it says, the compensation for the loss of damages. The most common remedy for the breach of contract is compensation or loss or damages suffered due to the breach. So here the party which is the defect have to pay the compensation or bear the loss by their conduct when there is a loss to another party. Then we have type of remedies under the breach of contract. The first is damages. Damages can be in the form of compensatory, which covers actual loss caused by the breach. Then we have consequential, cover loss from the special circumstances known to the both parties, nominal, a small amount of breach, and no actual cost. Then we have a specific performance. We will ask the other party to perform the conditions. Then we have injunction. Again, court orders the breaching party to stop an action such as violating a non-complete clause. Then we have contempt merit. This is really important. Payment of services performed when there is no formal contract exists or work is incomplete. Then we have a case law in this, Hadley versus Baxendale, where the established that damages are limited to loss. Then we have a specific performance, I guess. Okay, yes. A specific performance under the section 10. In some clauses, the remedy is a specific performance may be ordered. It is this remedy can be availed from the. It would be depend upon the court of law if they will allow. A specific performance is typically granted when a person monetary compensation is not sufficient to the remedy. The thing is, if there is a contract of service, so in that situation, the monetary compensation would not be sufficient. It would be the deficit of service. In this situation, the specific performance would be initiated, and the work which is to be performed by the party would be taken into consideration. Then we have injunction. In this particular thing, the court directs the party would refrain from taking any further until action until and until it has been fully decided by the by the court. Then we have quantum merit. As much as quantum merits, it is basically we can understand when there is a when parties are in the construction of road. In case that contract was to a contract was for the road was 100 meters. Just for the basic example, if road is completed at 50 meters, so in this situation the contractor is competent to claim that the work which he have done for the 50 meters, because there are monetary expenses in performing these activities. So initially this whole contract was not fulfilled, but quantum merits can be claimed as 50 meters he have completed. It took the resources time of the contractor, so he can ask for the merits quantum for the work which he have performed. Then we have Hartley versus Baxendale. We have already discussed. Then we have contingent contract. What are contingent? One where the performance is dependent upon the happening and not happening of a specific event in future. So the contract is conditional and performance depend upon the certain future event. And insurance contract where payment is made if an accident occurs. So these contract are considered as contingent contract. Contract validity. Event must not be impossible. The event must not be uncertain but possible. So these condition has to be taken into consideration. Performance of contract. We have general rules under section 37. Both the party must perform their promises as per their agreement. 38, if performance is done by the specific person, only that person must perform it. That also a important consideration. Section 40, 41, it's a time and place of the performance must be clearly specified in the contract. It should not be vague. Again, we have section 43 and 45. Performance by the offerer, party making the offer and the offeree accepting the party must have follow the terms and condition of the agreement. Then we have discharge of the contract. A contract is discharged when rights and obligation of under it are indistinguished. Mode of performance. By the performance, contract is discharged when all the terms and conditions are complete. Section 63, there's by agreement, party mutually agrees to discharge the contract. By breach, of course, failure to perform the contract result is the discharge. By the impossibility, failure to perform the contract result is the discharge. By the impossibility, when performance become impossible due to natural disasters. Then we have lapse of time. When contract is subject to the time limits and it expires by the operation of law, events such as death or regularity or changes in legal changes. Then we have quasi contract. We have discussed a small thing about these contract. What are these? A quasi contract is contract like obligation imposed by law to prevent unjust enrichment, even though no formal contract exists. So basically, here there is an absence of any specific agreement agreement or any contract, formal contract, but it puts an obligation upon the parties to perform certain duties which are considered under the valid contract. First one is supply of necessities. Section 68, duty to pay necessity provide to someone incapable of contracting. Example, minors. Example, a guardian or buys food for a minor who is unable to contract. The guardian can claim the payment for necessity provided. Then payment of by mistake, right to recover money paid by mistake. In case the person accidentally pays a bill for a good that didn't they didn't order, they can recover the payment by the mistake. Then we have liability of good delivered. If goods are delivered and benefited from, the receiver must pay. A person receive a package of books by mistake but decide to keep them, they are liable to pay for the good which they have received. Non-gratuitous act, liability for service rendered without a contract, even when offered as a gift. The person voluntarily repairs another car without an agreement, there is an obligation and to repay for the repair cost of repair to the person. So these are considered as a quasi contract. Here we have key points. Then we have contract of bailment and pledge. What it says, bailment says a contract where a owner of good delivers them from another for a specific purpose, giving your car to the mechanic for a repair. Rights and duty, the bailee is responsible for safekeeping the good and must be returned them after the purpose is fulfilled. Then we have pledge. What it says, a specific form of bailment where the good are delivered as a security for payment of debt, pawning a price of jewelry to a pawn shop. Then right of duties, a pledgee have right to sell the good if debt is not been returned in the stipulated time. Then we have agency. What agency says, agency is a relationship where the one person agent is authorized to act on the behalf of other principal. The types of agency would be the express agency created by the direct agreement. Then we have implied agency, arises by the from the circumstances or conduct of the parties. Then we have agency of ratification. The principal approves the action of the agent even if were done without prior authorization. Then we have the key difference